Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1151 et al. United Steel, Paper and Forestry, Rubber, Manufacturing, Energy, Allied Industrial and Service Workers International Union, AFL-CIO petitioner versus Environmental Protection Agency. Mr. Peterson for the Industry Petitioners and Olin Corporation, Ms. Rabinowitz for the Labor Petitioners, Mr. Durkee for the respondent, Mr. Segar for the respondent interveners, Mr. Bellingrad for the rebuttal.
Good morning.
Morning.
So, Mr. Peterson,
Yes.
it's my understanding that you will be presenting opening argument on behalf of the industry petitioners and Olin Corporation. Is that correct?
Yes, Your Honor. And our thought was I would use 7 minutes of our total 10 minutes allotted time, and then counsel for Olin would do the rebuttal. We'd reserve our 3 minutes and he would use it for rebuttal, if that's okay with the court.
That's fine, as long as the rebuttal is a true rebuttal and doesn't raise any new arguments.
Absolutely.
All right. Please proceed.
Thank you. May it please the court, my name is Rafe Peterson. Remand is appropriate in this case. EPA's request meets 3 basic criteria of this circuit. The agency has offered a reasonable explanation for its request. The request is not frivolous or in bad faith, and it would not unduly prejudice the non-moving party. First, with regard to the reasoned explanation, EPA has made clear that it intends to reconsider the 2024 rule in its entirety, including with respect to the issues that are before the court and other issues as well. They'll provide for public notice and comment, giving all parties to this case and other parties the opportunity to participate. And they've given a timeline committing to starting the process in June and wrapping up in a year. The request is not frivolous or in bad faith. They've asked to reconsider certain legal and policy priorities, including the four main issues at case here, as well as others. And they have not, as the interveners have suggested, manipulating the process. They've simply decided to initiate a new rulemaking. And a change in administration brought on by people casting their votes is a perfectly reasonable basis for an agency to seek a remand of a rule that's currently being considered.
With the demise of Chevron, we have to give our best interpretation of the statutory text, and to the extent that we do that regardless of what the agency says and what administration the agency is operating under, why shouldn't we, to the extent that there are challenges based purely on statutory interpretation, why shouldn't we just decide those? I mean, after all, Congress wanted set up this system so that these rules could be in place, and they're already way behind.
Yes, Your Honor. Well, I guess a preliminary matter, the Loper Bright decision didn't displace the standards for remand. It stands for the proposition of a standard of review, but there still has to be an agency action to adjudicate. There still has to be adversarial parties. And with the remand request and our side agreeing to it, there's essentially no more adversarial proceedings. And I would also add that
Still a disagreement about what the statute means.
there is a disagreement about what the statute means, but this case goes far beyond simple statutory interpretation. Probably the best example.
You may be right in some policy considerations where the agency allegedly has discretion not within the Loper Bright best reading of the statute. Maybe so, and maybe the court would consider, we don't have to weigh in on that. But on a regulation that's been promulgated and a party has properly raised issues about it, regulated parties, it's properly before us. It's not a big deal.
Well, Your Honor, with all due respect, I think it is a big deal in this case because all of the way this rules work, there's a lot of these decisions are intertwined. And so the agency has said that they're going to go back and take a look at the entire process. And so what the people who are opposing this remand are really looking for is, they say, in their own words, they're looking for guidance on the new rule. And they're looking for guidance as to the best reading in order to apply it, to shoehorn that into other decisions. And we believe that's improper under just the basic criteria of the remand. And these also, I would say that these aren't purely legal questions. The PPE is probably the best example, right? So there's multiple parties have a fundamental disagreement about EPA's obligations. There's disagreement about the word choices and what it even means. There's a disagreement about whether or not it's ripe for review. And also there's a disagreement about the standard. The labor petitioners believe that question should be looked under.
You're right. That might be one in the category in which the court might say, that especially because it might not be ripe, you send it back. But you gave the best example to support the point you're making. The other examples, there are a couple of others where there's straight out statutory interpretation questions. And a question as to what the statute means, straight up or down. Lots of arguments on either side. The agency has taken a position and review was sought properly. And that's the other way. The remand possibilities are not mandatory rules of law. They're possibilities, that's all.
Yep, absolutely, Your Honor. And it is subject to your discretion.
Right.
But in this case, for the purposes of judicial efficiency, all of these decisions are intertwined. The
It's not
agency,
inefficient for us to give our response to properly challenged legal questions that are before us. An agency always has the possibility of starting new notice and rulemaking if they think it's appropriate. That's not for us to decide. For us to decide is, do we have a case properly before us? And if so, decide it and move on.
right. And we think at this point that, for the things that we're arguing, that, because we're no longer adversarial, there isn't really a case in controversy anymore. As briefed by USCPA, when we conceded to the remand, it's dismissed as a practical matter. There's no more adversity. So in that case, anything that would be offered would be akin to an advisory opinion. And we also think, for judicial efficiency.
You're clearly adverse on certain of the issues, counsel. You clearly disagree on certain of the legal issues.
We do, but we
Right.
have, no one has any way to predict what EPA is going to do.
That's always a problem in administrative law. An agency can always decide, well, let's do this or let's do that. That's not our concern. But there are clearly adverse sides here. There's no question about it. I just spent Lord knows how much time going through all the materials that have been submitted. There are strong positions being taken on both sides of several of these issues. You're right. There are a couple of them that maybe the court in its wisdom would say, no, maybe this isn't ripe, and leave it for a later day. But there's several that are straight out legal issues that have been properly raised. They were promulgated by an agency. There's a regulation on the books. There's a statute on the books, and the case is properly before the court.
Right, but I do think there is a risk then of piecemeal review, in the sense that the agency is, this is going to be back. It's not like it's not going to, it is possibly going to be back before you again, but I think the principles of deferring to the agency and letting the agency take another look at this, they've asked to take another look at it.
Where does this court's authority come from to essentially remand to the agency without vacature, without deciding any of the merits of the case?
Well, whether or not there's a case in controversy, so they have.
But you're not dismissing your lawsuit. You're not seeking dismissal of your lawsuit, and the EPA isn't confessing error.
Correct.
So what are we doing here? I mean, this is Article 3 court. We have a case before us where industry petitioners have challenged a rulemaking on a number of grounds. Where does our authority come from to simply just send the rule back?
Well, when the agency asked to have her remanded back and we consented to it, or we agreed with it, there's no longer a case. We're no longer adversarial, so there's no longer a case in controversy on the issues that we've been briefing. It's the functional equivalent of having the case dismissed.
Is it the functional equivalent? Because the court is still, I mean, you haven't sought to have the case dismissed, and the EPA hasn't confessed error.
Right, they haven't confessed error. So then I think that just goes back to the typical principles of whether or not they've offered a reasonable explanation, whether or not it's frivolous or in bad faith, and
But
whether or
I'm
not.
asking you a question about authority. Where in the APA or, in general principles of the judicial power, do we have the authority to give that remedy? Where does it come from?
Well, your authority to oversee cases and controversies that are before you. Just the fundamental
But you're-
principle about whether or not this is,
Right, but where does the authority come from to give this remedy, to not decide a case, but to basically just send it back to the agency on a rulemaking, not on an individual adjudication or license or some type of particular private action? I mean, you've challenged a generally applicable rulemaking.
correct? And then it's your fundamental, I mean, under the APA, the fundamental right of the court to review that action.
We can review it, but then we would have to find that it's contrary to law, that it's arbitrary and capricious. But you're saying don't make any sort of legal determination, just send this generally applicable rule back.
Correct.
Can you point me to something in the APA that allows us to do that?
I can't, Your Honor. I'm sorry. I don't think I understand the question.
Can I ask this specifically with respect to personal protective equipment, PPE?
Mm-hmm.
There's an argument that PPE should not be considered a non-risk factor under the statute, right?
Correct.
Then there's another argument that it should not be considered a condition of use under the statute.
Mm-hmm.
So regardless of what the administration does on remand, whether it keeps the rule, changes the rule, isn't that legal question going to present itself? I mean, I guess we have to assume that there will be some party that doesn't like the answer that the agency gives to that question, and that they will bring a petition. But, I mean, isn't that issue going to still be there, regardless of what happens on remand?
I mean, I think that's speculative. I mean, we really just don't know. I mean, the agency is going to take back the entire rule, and it's going to be subject to public notice and comment, and they're going to try to come up with a policy. I mean, they could find something that would work for both parties, for all I know. And I think that's just.
Kumbaya on remand.
Yeah, I mean, again, I think that's the purposes of the remand, is to allow the agency to take a second look at it through public notice and comment, and all the parties here will then have their opportunity to present their views, and the agency will try to issue an interpretation of PPE. So we really don't know how it's going to be addressed going
We've had
forward.
an opportunity for years. The views, I'd be shocked if there were more views. There are an awful lot of views out there. At least I've had to wade through an awful lot.
Yeah, I mean, I will agree that this issue has been, subject to different levels of review, but it's been part of the reason has been elections. And, it still is the prerogative of the agency in the first place to promulgate these regulations and try to address these policy decisions and these interpretations. And so we're asking the court to exercise discretion and grant the request for relief and allow them to, an opportunity to figure this out.
If my colleagues don't have any further questions on the remand issue, thank you for presenting your argument on that. I mean, if you want to pursue it further, that's fine. But given the time, why don't you move on to the merits, and we'll give you time.
So we have three primary issues. And it all goes regarding the regulatory framework that is issues here. But as we've noted in our briefs, they're all intertwined, right? The all conditions of use is our first argument. And in that, EPA said it will not exclude conditions of use from the scope of risk evaluations, but a fit for purpose approach may result in varying types and levels of analysis. And we believe that under TSCA, the EPA has two levels of discretion from the statute. And first, the EPA must determine which uses of the chemical fall under the definition of conditions of use, right? And then second, they publish the scope of the risk analysis, including the hazardous exposures and conditions of use they expect to consider. And we challenge the notion that they will not exclude conditions of use because we believe that was.
Wait. You said the first, I'm not sure where you're reading that in the statute. The first thing they have to do is to determine whether a chemical substance presents unreasonable risk.
Right,
That's their first responsibility.
right.
That's the overarching. As to measuring it at the possible regulation stage where you would take different uses, which is what you seem to be complaining about, they do it. They just apparently not in the order you want, but the statute does not command what you're suggesting. The statute says the agency conduct risk evaluations to determine whether a chemical substance presents an unreasonable risk. Substance by substance. That is not the same as possible uses of that substance, which they do later in their regulations. Why is that inconsistent with the statute? What words am I missing?
Conditions of use.
No, conditions of use talk about, if you read that whole paragraph, to determine whether a chemical substance presents an unreasonable risk of injury, blah, blah, blah. Under conditions of use comes at the very end after the instruction and direction to the agency has already been given. And what that is description is just saying what will happen at the regulation stage. They're talking about, that then we'll figure out how this makes a difference. What you're asking for is not missing. It just apparently doesn't come at a time that you think it should come. And I don't see where the statute requires that it. Where does the statute say the agency shouldn't determine whether a chemical substance presents an unreasonable risk? That's exactly what the statute says.
It should, but the way the statute works is that first the agency has to figure out what are the conditions of use? How is this chemical being used?
That is not what B4A says.
It's the risk evaluations are based under the conditions of use.
That is not what it says.
And that's further supported by how the scoping is. Because the scoping is they publish the scope of the risk evaluation to be conducted, including hazards, exposures, conditions of use, and the potentially exposed or susceptible populations the administrator expects to consider. So then they lay out the uses that they expect to consider.
When we get to a later stage, after they've considered each substance to determine whether, that's a screening. It's clear what the statute's doing. It seems to be consistent with good science too, to take substance by substance, determine the level of risk. As to how you regulate, that will change. They admit that may change depending upon different conditions of use, but that's at a later stage of the process. There's no threat of industry or anyone else being regulated with respect to a condition of use that you can reasonably show there isn't any concern here. And that doesn't change merely because at the beginning, the agency goes substance by substance to determine whether, as the statute says, a chemical substance presents an unreasonable risk. That's what the statute says.
Well, that actually gets to our second argument, because it with all due respect, it does. When they use the whole chemical approach, they put all the conditions of use into one analysis, right?
That's right.
And if you have 100 safe uses and you have one condition of use that they determine as a risk, then when they move forward to the next level of analysis, the risk determination, by looking at the chemical substance as presenting a risk, all the things that they know do not present a risk will also have to be considered on the next level. And that has an effect on our clients because they end up having to produce data. So they're producing all this information, they're spending all this money, and they're essentially being, it's like almost like a kind of like a false determination, because they know that these conditions of use do not pose a risk, but because of this whole chemical approach, they ended up considering them all together as a quote substance.
Mr. Peterson, though, that's a good argument for why your second point you know, is a good challenge to the regulation, but that still doesn't answer why the all conditions of use part, your first argument, shows that the regulation is unlawful. I guess my question is, why isn't the EPA's interpretation under this first challenge at least a permissible reading of the statute? It may not be the best reading, and there might be other possible readings, but why is the EPA's consideration of all the conditions of use at that, you know, at the risk evaluation stage, at least permissible under the statute? What makes it impermissible, I guess?
Well, what I guess what we said is they can move forward and evaluate all conditions of use, right? We're not disputing that. It's just that the statute doesn't mandate that they evaluate all conditional uses that are
Well, it
suggested.
doesn't mandate it. So is what EPA did permissible? Because you're saying that what EPA did is contrary to law.
It is, yes.
So how is it contrary to law? You just said that they're not required to consider all conditions of use, but that's not an argument that it's impermissible for them to consider all conditions of use.
It is permissible for them to consider all, but that isn't what they say. What they say is they will not exclude conditions of use. And that's inconsistent with the statute, the plain language of the statute and the entire statutory framework, where, you know, some of these chemicals have hundreds of conditions of use. And, you know, part of what Congress was trying to do was to speed up this process. And there's these 3-year deadlines on this. And what this ends up doing is they're almost biting off more than they can chew by saying they will not exclude, as they had under the 2017 interpretation of the rule, by saying they cannot exclude all conditions of use, they're tying up their own discretion. Because again,
But what's the difference between saying they won't exclude any conditions of use and saying we're going to consider all conditions of use? Aren't those the same? Those are equivalent things.
no, because they're essentially saying they must include all conditions of use. And
Well,
that's
they're
not in the
saying
statute.
They will do that they've decided as part of their discretion to consider all conditions of use. That may be bad policy. It may not make a lot of sense. Maybe it's arbitrary and capricious, but I don't see what your argument is that that decision is contrary to law.
It's contrary to law in 2 ways. One, again, it's the definition of condition of use as determined by the administrator, right? So that gives them discretion where and I think EPA agrees with them that the first step.
That discretion is about whether the administrator decides something is a condition of use.
Exactly.
To begin with. So EPA is not
Yep.
affecting that discretion. They're just saying once the administrator has said these, say, 10 things are a condition of use, we will look at all the conditions of use in a risk evaluation. So that's not eliminating the administrator's discretion to decide what in fact is a condition of use.
It's the second step, right? It's in the scoping. So in the scoping, then they're supposed to publish the scope of the risk evaluation and the condition of use they expect to consider. And if you look at the legislative history, it's shown that, you know, it makes clear EPA has to make a determination on the condition of use considered in the scope, but the agency is given the discretion to determine the conditions of use the agency will address in the evaluation of the priority chemical. I mean, all of this is about prioritizing risk, and that they're supposed to look at the things that pose the greatest potential risk. And so by including things that the agency has science and knows do not pose risk, they're imposing harm upon our clients, imposing its costs, and they're, you know, requesting information. And it's also ensuring that they're not going to meet any of their deadlines, because there's a 3-year deadline. And that's exactly why this law was amended in the first place, because Congress realized they weren't able to get through any of these chemicals. So this is really all about prioritization and attempting to focus on the things that raise the greatest potential of risk.
Where in the statute does it talk about that prioritization?
Prioritization is the first step in the process. So the first step is they're picking the chemicals, 10 or 20 chemicals that are going to be prioritized for review.
Sure. So once they've decided that, where's the language about the prioritization of particular risks of a chemical that's already been prioritized?
As I was saying, that's in the legislative history. The legislative history told them to
But I asked
focus.
you where it was in the statute. It's not in the statute.
It's not in the statute now. But what is in the statute is scoping. And we believe that the scoping should be interpreted that they're supposed to, that they're given this authority to exclude conditions of use that they have information on that are not otherwise, posing a risk. And it's pretty simple, and that's the process, and that's how it worked. And I think it's going to allow them to meet their deadlines, and it's part of what Congress envisioned. And they haven't explained, that was how they interpreted it in 2017, and they haven't explained adequately their switch on how they're now making risk evaluations. So they haven't justified the change. All they say is that they just cite to the legislative history, but as we've pointed out, we think the legislative history favors our argument. And it also affects.
Say about any of the other arguments in your brief.
Well, it also affects preemption. I mean, another big point of this is that if they don't focus on the conditions, preemption is driven by conditions of use. And preemption is important to the chemical manufacturers and it's important to the states. And so again, if they're making findings that a substance, you can't preempt on the basis of a substance. You can preempt on the basis of uses. Certain chemicals are safe in a manufacturing process in a closed loop system, but are not safe if used by a homeowner, in their basement stripping paint or something. And preemption is really important to the statute and it's driven by the decisions made in the risk evaluation stage. And so I think that's another thing that really supports our argument that all these decisions should be done conditions of use and not done. The agency does have authority if it's necessary to look at worst case scenarios, et cetera, but it's not, then they just have to describe what they're doing and why.
So you would have wanted the statute to say in B4A, the provision should have said to determine whether a chemical substance presents an unreasonable risk of injury to health or the environment under each condition of use. That's not what the statute says. And that's the difference here. And that's what you're arguing. You keep ignoring, I keep reading your brief. It's really kind of strange because you skip over the telling parts of the statute that are absolutely inconsistent with what you're arguing. And what you want is what I just read. I was trying to figure out, that's the formulation you wanted, which proves the point. You didn't get it. It's not in the statute. That's not, each is not there.
But the each is done at the scoping level.
No. You can't disregard the 5 prior lines in the statutory provision, which says the agency is expected to determine whether a chemical substance presents an unreasonable risk.
Under the conditions of use.
They eventually say, that's what you're doing that so you have the material to deal with it when you get to the regulation stage to determine whether a particular condition of use should be regulated. You're not losing what you want, the protection against regulations where there is no real risk. That's the thing that's so strange about this. You're getting what you want. It's just not in the order in which you want it.
Well, I will say that, the importance of the conditions of use is that it lines up it's the only way to look at a chemical. They look at the chemicals based on, looking back at the definition of how they're used. Is it in manufacturing?
That's not the only way to look at a chemical. You can take a chemical as a whole, and part of what's going on here is screening. On certain substances, in the way the agency is proposing, what the statute requires, you screen out certain substances because you find out no risk.
Absolutely.
Okay, and that is a perfect, not only good approach as I understand it from science, but it's what the statute says to do. Take each substance, one by one, determine level of risk. And some are going to show none, they're gone. So they don't even get to the stage where you're thinking about whether or not to regulate and to what extent, which brings in conditions of use. That's what that last hanging couple of words in the statutory provision is referring to. When you get to that stage, yes, of course you look at the kitchen.
But what we're saying is you start at that stage. You look at, are they manufactured? Well, it's the only way to have a workable program. So they start off looking at manufacturing, processing, again, several hundred to 1,000 different conditions of use. They can't just look at them all at once. A chemical acts differently if it's being used as a pesticide, if it's being used as an additive to a gasoline, or if it's been used in a children's toy. And each one of those is a different determination that has to be done by the agency. And so
And it eventually is done if and when we get to the stage of regulation where there's a question.
but the problem is that
And what we won't waste time doing at that stage is worrying about substances that they've already determined present no risk of use. No threat.
But the real problem with the rule is that they don't articulate what the court is saying here, because when they get to the risk determination, and this is why we have a due process argument, we don't know what they're going to do with that information. We know, yes, this is not presenting a risk.
I can say.
And they know that.
The parts of their brief that make it pretty clear that that's what they intend to do at the later stage. It's plain as day. I mean,
It's post hoc. It's not described in the rule. And then so you're gonna end up with a whole chemical where you're having 99 safe uses, one unsafe use, and yet you're going all the way through risk determination on all of the uses when they could have been screened out. They're meant to be screened out at the scoping stage because they're not posing a risk. They should focus on the hazards that pose the greatest risk. And again, it's these different categories of manufactured, processed, distributed, commerce, used, or disposed of. I mean, they use or. So you're looking at these different uses, and it has a real impact on the agency because the agency isn't going to be able to get through these. That are costing millions of dollars for conditions of use that pose no risk, but they are pulled into that process. And then companies deselect, and you have people thinking, well, if it's a risk, why don't I find another chemical? So it has, this failure to do it at the front end where they're supposed to has real world impacts on the industry.
All right, any of the other issues you want to say anything about? Are you going to rest on the brief?
Just give me one. Finally, I would add, again, this is not a hazard law, right? It's a risk law. And so the interpretation that is being offered by EPA is treating it more in terms of hazards, not of risks. And the law was written to look very specifically at different risks as they're actually the actual conditions of uses. And when you use the whole chemical approach, you're essentially creating a hazard law, and there's other agencies that look at that, right? It's not like these aren't being, and that's, part of our argument on usurping the role of OSHA. They're ending up making decisions that are looking more at hazards than actual conditions of use. And that to us is really the core. Those are the most important words of the statute to us, because that's the core of what holds together and drives all the decisions, is looking how they're actually manufactured, transported, used, and each one of those is, and that's how it works too. I mean, that's how they, they'll have 50 or 100 of these and they compartmentalize them.
Can I just ask you one question about your PPE argument?
Mhm.
So the EPA's regulatory language here seems to me, at least arguably, somewhat obscure. It says EPA will not consider exposure reduction based on assumed use of PPE as part of the risk determination. And industry petitioners understand that to mean EPA won't assume that employers are complying with OSHA regulations. But the actual regulatory language doesn't make any mention of what assumptions are, sort of off the table, like whether it's OSHA regs or something else. So how should we understand this language? Because industry petitioners assume that this is about, about PP use under OSHA regulations.
I mean, the way we look at the full sentence, I mean, in a nutshell, I mean, they'll consider any available information that PPE will not work and that there's non-compliance, but they will not consider whether or not it works. And so they're not willing to, because I think it is, I'll say it's a clumsily written sentence, but we read it and the way it's been implemented is that they're basically not considering PPE and risk exposure. So that is inconsistent, plainly inconsistent with the statute for a number of reasons. It's best available information. I mean, information that EPA possesses or can reasonably generate, obtain, and synthesize. So if they're presented that information, it should be considered. And EPA shall take into consideration hazard and exposure information. Again, PPE goes to exposure. And so it should be a key part, and it leads to decisions that are, and we give some examples where, because they don't consider PPE, and OSHA does, for example, they set limits that are much, much lower and harder to achieve, whereas had they simply used PPE, they would reach a different conclusion. So they're basically not considering it at all.
But isn't there a sentence later on that same page, looking at JA 45, on the far right column, about midway down, the paragraph that begins with "other commentators took issue," and about 7 lines down, they say the proposed change in this rule is that EPA will not assume use of PPE for purposes of the risk determination, not that EPA will assume no use of PPE. Likewise, EPA is not asserting there is widespread non-compliance with OSHA requirements.
Yeah, I think that language is kind of inconsistent with what they wrote, though, right? Because they say EPA will not consider exposure of risk reduction based on assumed use of PPE. I mean, that for all intents and purposes, means they're not considering it. I mean, you could take out the assumed.
So we're supposed to say that they meant what they said in one sentence, but, you know, a few paragraphs later, they didn't mean what they said in the other sentence?
Well, the regulation that they promulgated says they will not consider exposure reduction based on assumed use of PPE as part of the risk determination. And that's also, and we briefed this, that's also what they're doing. They're not using it at that stage of their analysis. So they've lived up to it. And again, we think it's arbitrary because when they will take into account available information due to the absence of it. So it's internally inconsistent that and one thing they respect the fact that they have to take into consideration the exposure information given them, but they say a certain category they're not willing to consider.
I mean, why isn't the fair reading of this that, you know, the statute requires them to take into account available information and the best science, right?
Yep, shall, yeah.
And why isn't the best reading of that is that we're not going to make assumptions, but where we have information about how PPE is used, because there is data on that, and what compliance rates there are, we're going to take that into account.
Well,
why isn't that what really they're saying?
The reality is that's not how they're interpreting. They're doing risk evaluations without considering its use, and they're setting exposure limits based on it not being used. And so, again, as you pointed out, I mean, it's basic information that they normally would have, right? Some of these chemicals have been regulated for decades, and it pertains to exposure information. So if they do have this information, I don't know how else you would use it other than assuming that PPE works. I mean, the purpose of it is to address exposure, right? A pair of gloves, a mask, or whatever it is. And so they're engaging in, this kind of strange word game where they're saying, well, we're willing to consider that it's ineffective, but we're not willing to consider that it is effective. And that's because they won't assume that it reduces exposure. That's effectiveness.
I mean, OSHA writes violations every day because people don't use PPE. I love HGTV and other shows of that nature, and I see people cutting granite countertops and tearing off walls that probably have lead paint and asbestos in them and all sorts of things. And they may have no masks at all on, or some sort of a bandana that's not really a proper
Right.
mask.
Well,
I mean, we know that there are lots of rules and regulations about what's supposed to happen, but isn't the EPA trying to regulate here, and isn't TSCA, the Congress requiring the EPA to mandate, to regulate based on the real world and what we know about PPE use? And why isn't that essentially what this rule says it's doing?
Well, they are because it's the conditions of use, right? In your scenario, they would set the events of exposure different for Johnny homeowner, tearing out asbestos, as opposed to a highly regulated industry that's working with a similar product where the use is mandated. And they've said in the past that they wouldn't assume non-compliance with OSHA regulations. So they've said that in the past, and that's a sound decision, right? So it all comes back to the conditions of use. A product that's available to a homeowner would be given a different level, a different assessment of the exposure than to something that's an additive to a gasoline and a closed loop system in a manufacturer in a highly regulated industry. So they get to that because it's all driven by the conditions of use. And, our point is, in the highly regulated industry, they're basically saying, we're not going to consider the obvious fact that everybody there is regulated by OSHA and wearing masks or using whatever PPE is supposed to protect against whatever exposure. But they will, for some reason, consider the absence or ineffective use of it. And that's contradictory and arbitrary and capricious in the manner of which it's all driven by the same decision of taking into consideration hazard and exposure information. PPE is at its base exposure information. And if they have that information, they should deal with it at the risk evaluation level if it's presented to them. And they're saying they're not going to consider it because they say they can't assume that it works. Well, then they're not really, if they can't assume it's going to work, then why consider it? It's not, in that case, it's not being considered at all.
I just want to ask. I want to make sure I understand both thrusts of your argument on the point we were discussing earlier. Isn't it true that aggregations of various conditions of use may produce different levels of risk?
Yes, and under.
If you do it in the way that you're proposing the step, won't you eliminate a full understanding of that if you eliminated a condition of use?
No, absolutely not.
Take it as a whole, you surely will find you take the substance as a whole and measure its risk, you have all of that information.
Well, the aggregation is dealt in the information, and what the statute says is the agency should describe whether aggregate or sentinel exposures to a chemical substance under the conditions of use were considered and take into account where relevant the likely duration. So the agency always has the discretion to do that. We're not saying that they shouldn't do that. They always should consider these aggregates.
What they've essentially done in following the statute exactly as written is to consider the substance as a whole in the beginning, and they have all of that information when they get to the regulation stage. And they look at different conditions of use. Because as I'm understanding, and I don't think I'm missing it now, your only concern is you might get caught in the regulation stage and have a regulation where the condition of use didn't warrant it. And the agency has made it absolutely clear, although you're saying it's only me and you didn't see it in their argument, which I don't understand. They are saying that is absolutely accounted for pursuant to notice and comment to the parties who will know that with each regulation as to specific conditions of use, here's what they're proposing to do.
Well, when the problem is when they're going to address it at the next stage, right? So
Before there's any regulation, which of course is what I was representing industry, I would want that too. You can't regulate us without making a determination as to whether there's real risk here on conditions of use. They have said that is exactly what they're intending to do.
But the harm is in the process, right? So they're ending up.
I'll have to hear their response to it. I'm not getting where your harm is coming from if the agency follows a procedure which puts, as the statute says, determination as to whether a chemical substance presents an unreasonable risk. That's the direction in the statute. I don't understand where all the cost is building up if they do that at the front end, and then they consider the conditions of use regulation piece of it at the point when they want to regulate.
Right. So what happens is though, then they, the regulated industry is supposed to provide, is forced to provide data to EPA about all the uses, right? And they're forced to provide, even those that pose no risk, forced to comment on rules on chemicals that they use in
That's the
manufacture.
question. That's not the answer. Even those that don't, that's what they're trying to determine.
But
In
they-
measuring the substance, that's what they're doing. They're trying to determine where might there be problems and where are there none? And is this a substance with respect to which there are no problems? And if so, then we're done with that substance. That's the way the statute's written.
But the statute is, again, we believe it's not written that way in the sense that, the substance, big S, is deemed to pose an unreasonable risk, regardless of the fact that 9 out of 10 of the uses do not pose an unreasonable risk. Our point is that those should be let out of the process earlier and not have 3 to 5 to 6 years where you're not getting it's affecting
You want to do
preemption.
the last stage first, even though no determination about regulation has been made. And so
Well-
my question to you is, why would they want to waste the time there? They just want to understand the substance. Is there possible risk here? They're not saying that equals
Well, it's,
enough risk with respect to every possible condition that they found, of use that they found, warranting regulation.
well, the thing is, they were supposed to get through this all in 3 years, and it's just not possible if they consider every conceivable risk in the scoping stage, every conceivable risk as they work their way through it. And that's the reality of what is happening. And it has real impacts, and it has market deselection, and it also has impacts on preemption because, if a state, all these decisions, if you say the substance itself poses an unreasonable risk, then every single use, even uses that are known to not pose a risk, the preemption follows that. So every state and everywhere else that it's working, that's going to then drive that decision. And so it really, that's an important thing to our clients as
See, I
well.
can't argue with you there because I don't have the information, but that sounds profoundly ridiculous. That if I'm in a state and all I see is the first inquiry and there's no determination that the agency has made to regulate the condition of use with respect to that substance, I'm going to go ahead and act with respect to anything anyway? That makes no sense.
Well, the way the preemption works is that it's driven by the scope of the risk evaluation. And so for this period of time before they get to the regulations, every use, all 100, 200 of them is deemed as posing a risk. Whereas if they were making the decision earlier, then those uses could continue and it's not preempted. So that is a big deal to the statute and a big deal. And that might be one of the biggest effects here is that, again, by not making these decisions as Congress meant at the earlier stages, you're changing really everything. You're changing the way the chemicals are bought and sold and manufactured. You're having parties decide maybe to no longer use that chemical because EPA says the substance poses a risk, even though there's a different risk if it's Judge Wilkins' homeowner show versus a chemical manufacturing plant. I mean, that's why the conditions of use are so important. It's based on risk evaluation, not something being hazardous. There's other laws that deal with a chemical being hazardous. This is supposed to be very focused on the priority chemicals and then the priority, the most important risks, the ones that really pose a hazard.
So they know how to regulate.
They know how.
So they know how to regulate, right? That's what this is all being done. And that decision that is made until they have made an evaluation with respect to the conditions of use where they think there's a threat.
I would say, Your Honor, they did know how to regulate in 2017 because the regulation that they promulgated then was consistent with the statute. And their proposal now is they're sort of a little bit of martyrdom almost. I mean, they're taking on more work and more analysis than they can possibly handle, and they're not getting through these regulations, and the regulations are having the effect that we talked about. They're, not using PPE is having these effects with how they're setting exposure ratios. It's having effect on preemption. So the concerns we raise are real and occurring.
All right, thank you. We'll give you some time. Well, we'll give your colleagues some time on rebuttal. Why don't we hear from, I believe it's the labor petitioners?
Thank you.
Good morning. I'm here on behalf of the United Steelworkers, the International Association of Machinists, and WorkSafe, and our petition is confined to the PPE issue. So,
Ms. Rivers, can you start with standing?
Sure.
How have labor petitioners demonstrated standing here? There are no declarations, there are no, I mean, where's the demonstration of standing that's required
okay.
by our rules?
The court's rules require that we provide declarations if the standing is not obvious. We are membership associations by law, and our members are exposed to these hazardous substances. And I will say that I've been involved in a number of cases under OSHA where the exposure was at issue, and we have never submitted declarations to the court, and it's never been questioned. And we would
Well,
be,
that doesn't,
okay.
I mean, that is irrelevant to our independent obligation to assess standing for, because you are seeking different relief from the other petitioners. You have to maintain your
we'll
own
be happy.
standing.
I would be happy to submit a declaration tomorrow. And it shows that
Well,
the steelworkers have members
That's
who are
not what our case
exposed.
law, that's not what our case law says. Briefs can't serve as evidence of standing.
In the past, we have never had a problem, and we've never been asked to do it, and
Can
so
you
we
point
did
us
not
to-
do it.
Under our authority, if you are trying to establish associational standing, you've got to demonstrate either from something that's in the record or by a declaration that, you know, you have one or more members of your association who are regulated or harmed or injured by the agency action. Is there something you can point us to in the record that establishes that?
Our comments in the record establish that our members are exposed in various conditions of use, and there was a case before the Ninth Circuit on the agency's initial risk evaluation for methylene chloride, where the steelworkers put in a declaration, and I'd be happy to provide that to the court. The steelworkers and the machinists represent many employees in manufacturing sectors, particularly the chemical manufacturing sector, that are directly regulated under TSCA. And we have submitted declarations in many cases that indicate that, and I'd be happy to provide that to the court. We did not do it in our briefs because we thought it was obvious and not necessary. I can't pretend we did.
Right, your comments are very generic that, I mean, it seems almost, I'm sure there are workers who are harmed by this rule, but that's not the
We
standard.
have members exposed to virtually every chemical that EPA has been considering, and we have participated in each of those rulemakings.
Why don't we move to the merits?
Okay, well, we urge you to decide this case on the merits, and I'd like to start by rebutting some of the things that my colleagues for ACC mentioned. I
To the
think,
extent that they're on the remand issue, I mean, to the extent that the agency intends to reconsider this rule, and it's likely to come out of that looking a lot different than it does now, and probably more similar to the 2017 rule. Why isn't this just a big kind of judicial waste of time for us to adjudicate this rule that's, not long for this earth?
I would say for two reasons. First, we and industry take diametrically opposed competing statutory, we offered competing statutory interpretations. We say they can't consider PPE. Industry says they must assume PPE use. Under this court's decision in utility solid waste activities versus EPA, which EPA thoughtfully cited for us in its motion, this court looked at a number of factors in deciding whether to remand or whether to address the merits. And one of those factors was whether a statutory interpretation would narrow the scope of the agency's discretion on remand. And we think that that's what the court ought to do here, because it has a live controversy where the competing statutory interpretations have been fully briefed, and it would prevent EPA from coming up with a new rule that is outside the scope of what the statute gives it discretion to consider.
All right. So on the merits of your PPE argument.
So first, I'd like to address the industry argument, because of course, if they win, we lose, and vice versa. So I think there's been a lot of confusion here. We think it would be reasonable for EPA to assume compliance with OSHA regulations, but the fact remains that no OSHA standard requires employers to control toxic chemical exposures at all levels of exposure. And no OSHA standard permits routine reliance on respirators as a means of protecting workers. Employers are required to comply with OSHA exposure limits, not to exceed them. The levels of exposure of concern to EPA and where it has found unreasonable risk are at least one order of magnitude below any level that OSHA has ever regulated.
But anyways, even if OSHA regulations are not as protective as you suggest they should be for exposure to workers, I mean, wouldn't that be part of what EPA would be considering? They're not considering, you know, they're looking at what the OSHA standards do. And if they're not, you know, addressing the risk sufficiently, then EPA can take further action.
Correct.
Right? So the fact that the OSHA regs might not be, you know, sort of as protective as you might want them to be for workers, it doesn't really say whether they should be part of EPA's
Correct.
understanding of risk.
Completely agree.
Okay.
So I'll give you an example. So the industry, the only regulation that they say EPA has ignored is OSHA's methylene chloride standard, which is what industry cites. OSHA's methylene chloride standard sets a permissible exposure limit of 25 parts per million. At that level of exposure, OSHA found that 3.6 per 1,000 workers would continue to get cancer. It didn't set the exposure limit at 25 because it fully protects workers, but because it would be infeasible for industry to routinely go lower, relying on engineering controls. EPA has found cancer and liver toxicity risks at 2 parts per million. OSHA doesn't regulate those risks. And so this whole debate about compliance with OSHA regulations or non-compliance with OSHA regulations is really sort of beside the point. Besides the fact, under this court's decision in the United Steelworkers, the original lead case, no OSHA standard can routinely rely on respirators all the time. An OSHA standard that relied solely on respirators would, by definition, under this court's jurisprudence, be infeasible, and it would be a standard that OSHA is not authorized to issue. So we think that this is just sort of a big beside the point. The second question on our argument, we think that the best available science and the direction that EPA not consider non-risk factors during risk evaluation requires that EPA not take respirators or PPE into account until the risk management stage. While TSCA requires EPA to integrate exposure and hazard information, our argument focuses on how you define employee exposure. Employee exposure assessment protocols require that exposure be measured without regard to respirators. For the past 50 years, this long-standing industrial hygiene practice has been incorporated into every single OSHA standard. All OSHA compliance measurements and employer measurements taken to comply with OSHA standards do not take respirators into account. NIOSH follows this practice as well. All the epidemiology studies describing the health effects of chemicals rely on measurements taken without regard to respirators. The practice is so pervasive that EPA has adopted the same definition of employee exposure in several risk management standards. The reason is simple. If you attach a sampling tube inside a respirator's facepiece, you break the seal, meaning it no longer can function the way it was intended. Against this background, we submit that taking respirators into account is simply not the best available science. Doing so is unprecedented. Despite decades of occupational risk assessment practice by various federal agencies, neither EPA nor industry has pointed to a single example of a federal risk evaluation where exposure measurements were reduced by evidence of the absence or ineffective use of respirators. As NIOSH told EPA, taking respirators into account is not a best practice. We also believe that TSCA prohibits EPA from taking non-risk factors into account, that by prohibiting EPA from taking non-risk factors into account, EPA cannot consider respirator use until the risk management stage, because it's a method of controlling exposures, and that's the appropriate point in time to do so. And if EPA takes respirators into account and it makes a risk determination based on some fraction of measured exposure, inevitably the agency will either have no duty to protect workers from exposure, or its risk management rule will aim to eliminate less risk than really exists. Either way, taking respirators into account during risk evaluation means mandatory TSCA rules will provide less protection to workers than TSCA requires. And we're not urging that EPA ignore respirator use. It is a reasonable means of controlling exposure, and it should factor into their risk management decisions. And so we think that we think the difference here, though, is subtle but important. If EPA relies on voluntary respirator use, and again, if OSHA does not require it, and employers are providing respirators anyhow, then the respirator use is voluntary. If they rely on voluntary respirator use to avoid setting mandatory exposure standards, then there is no enforceable limit to protect workers from overexposure. If EPA takes PPE into account during risk management, it will be required to issue mandatory enforceable standards that protect workers. In conclusion, EPA is required to rely on the best available science. The well-settled practice of occupational exposure assessment does not take respirator use into account when measuring exposure. Both OSHA and NIOSH told EPA it was contrary to the best practice to consider PPE during risk evaluation. Neither agency does so. Doing so inherently underestimates risk, and for that reason, it violates EPA's duty to protect workers from unreasonable risk. Thank you.
Thank you. We'll hear from respondent, EPA.
Thank you, Your Honor, and may it please the court, Dan Durkee from the United States Department of Justice, and with me at council table are Rachel Martinez, also with the Department of Justice, and Derek Gilliam from EPA's Office of General Counsel. And Your Honor, I'd like to start with Judge Rao's question at the outset about the court's power, the court's authority to issue a remand here. What we're asking for is the court to stay its hand. We're asking for the court to hold the case in abeyance while the agency proceeds with its announced intention to undergo reconsideration. That power stems from the court's inherent authority to manage its docket. We're not asking the court to take any action on the actual underlying regulation, to vacate it, to uphold it, to adjudicate it in any way. So the court does have, and I think that's been recognized in the court's precedents when the court grants voluntary remand. So the source of the power is the court's authority to manage its document. All we're asking is that the court stay its hand, not make a decision on these issues while the agency undertakes its process.
Where there are still petitioners challenging the lawfulness of a regulation, we're in effect, issuing a remedy, remand without vacator.
The place I disagree with you, Your Honor, is there's only one potential issue that that could be true. And as we explained in our motion, we don't think the labor petitioners are prejudiced in any way. There's 4 legal issues. 3 of them are brought solely by industry, and they're okay with remand. They're saying they don't want to engage. The PPE issue has both industry and labor. Within that PPE issue, there's several different, let's say, there's several paths, there's several flavors. There's the argument that you just heard about the assumption, whether EPA should assume PPE or not. We think, as we explained in a brief, we think that is an as-applied challenge. It's not ripe. There's no prejudice to any party to withhold a decision on that. Let EPA take another look at it, see what happens. It's not a facial challenge. The one facial challenge potentially is the labor petitioner's argument that the statute flatly prohibits consideration of PPE. But on that one, they're also not prejudiced because of the way EPA goes about making its decisions.
I'm not sure the question is one necessarily about prejudice, because my question to the industry petitioners is, where does the court have the authority to issue this relief? I mean, is the EPA confessing error on the 2024 rule?
No, Your Honor.
Because there are some precedents in which an agency confesses error and then we vacate and remand the rules sometimes. I mean, there are a couple of cases. There's not a lot of reasoning in our case law about why a remand is appropriate. Like, of course, I understand. I mean, there's a change in administration. New administration would like to take a different approach. But this case is still here.
The case is still here.
And so, what is our authority to simply ignore the case and effectively issue a remedy without deciding any of the merits? I mean, it seems the government should have some well-developed theory of this, because this is an argument that's being made in a number of cases.
Right. Well, and because we don't see it as the court issuing a remedy. We see it as the court doing what is common to have an abeyance while an agency undertakes a rulemaking. That's not unusual for the court to decide through its inherent power to manage its document to stay its hand while the agency undertakes rulemaking. I think the only potential issue aspect of this.
What's between an abeyance and a remand? So our cases, I mean, we of course can hold a rule in we can hold a case in abeyance for some limited period of time while the administration reconsiders a rulemaking or something like that. But our cases are quite clear that we can't do unlimited abeyances, just sort of open-ended abeyances. And an abeyance keeps the case still here.
Yeah.
But my understanding is what you're seeking is a remand to the agency, which would eliminate the case from our docket.
Well, perhaps it's.
So that is a particular remedy. And what is your theory for why we have the authority to do that?
Well, perhaps it's a terminology problem and not an authority problem, because the only exercise of judicial authority we're asking for is the court to stay its hand, because EPA has already announced its decision to go ahead and reconsider. There's no order necessary to direct the agency that here's a problem.
The agency can engage in a new rulemaking at any time.
Right. So to join the issue, I think problem is our position is that prudentially, the better course is not to make a ruling on these various issues while the agency proceeds. The agency doesn't need, as you said, the agency doesn't need the court issuing an order to allow it to reconsider. But prudentially, we're saying the court it shouldn't happen at the same time.
Isn't the rule in effect? Isn't the rule being challenged in effect as we speak?
Yes,
So the relief you were asking for, would that affect whether the rule remains in effect?
It would not, Your Honor. That's what EPA said in its declaration was EPA intends to continue to implement the 2024 regulation while it's reconsidering. There's no change. There's no need for the court to issue an order on that respect. The only thing we're asking the court to do is to stay its hand. Otherwise, the agency proceeding can go forward, and that's not controversial. The perhaps more controversial part is what does the court do while that's happening? And we're not saying the court has to, of course, stay its hand, but the court, I think clearly has discretion to wait. And here we've given prudential reasons why it makes sense for the court to wait.
So what is the government seeking? Are you seeking an abeyance or are you seeking a remand of the rule? Because those two things are not the same. An abeyance holds the case while the agency goes forward with new rulemaking. But the case is still here. We can
Right.
lift the abeyance at any time and
Right.
move to the merits. A remand, then the case is over here. And if industry petitioners want to, you know, I don't know, bring some other challenge or labor petitioners, then they would have to come back and
Right.
institute a new petition, which may be time barred or not, depending on, you know, what's happening. But EPA's position is we're going to continue to enforce the 2024 rule. So what are you seeking, abeyance or remand? I'm not sure that those two remedies are consistent. I'm not sure you can get both. How do you get both?
Well, two answers. One, we think this does fit within what the court did in 2018 in the solid waste case. But if the court today granted the abeyance and did nothing more, stayed its hand saying we are not going to act until the agency completes its reconsideration, we have a timeline, that would satisfy the government. That would be enough because the agency has already made its own decision to go ahead and reconsider. So the exercise of judicial power we're asking for is really for the court to stay its hand. There's nothing, I mean, remand in a sense, I think we were using the remand in a sense to communicate that the agency wants the decision back.
Remand has a technical meaning. When we remand a rule without vacator, that has a particular meaning. It's not just some sort of atmospheric idea.
Right. Well, and again, in the 2018 USCA decision, that's what happened. And that's the precedent that we pointed to. If the court is uncomfortable following that, then simply holding the case in abeyance and not making a decision until the court has the benefit of EPA's further reasoning I think would accomplish the same thing.
Can you cite two examples where we've held a case in abeyance on a rulemaking while a new rule was being considered, which could take a year, 18 months, 2 years?
I can't cite you chapter and verse like docket numbers, and those usually end up in unreported orders. But yeah, I don't think that's unusual for the court to put a case into abeyance while the agency reconsiders.
And do you have examples of that where the underlying rule isn't stayed? Because sometimes there will be a stay issued on a rule and then abeyance, there's no harm to any parties in the interim.
I think, Your Honor, I think we could provide citations to orders. They might not be reported decisions, but I don't think it's unusual to ask the court to stay its hand while the agency reconsiders a rule that's not
So we're
without vacature.
under your proposal, we would be holding the case as it is being presently presented in the present posture.
That's right. And then depending on what happens on reconsideration, the agency issues a new decision.
But on reconsideration, you're liable to make major changes in the rule, right? So then what have we held?
I'm sorry.
So then what have we held? What have we got now? You come back and say, we've completely changed the rules. So the thing you held, could you toss it, please? Is that what you're imagining?
It depends on what the agency says.
Well, let's assume that, because that's certainly one distinct possibility here. For example, if you went with interveners' argument on the determination question under the statute, that's a flat statutory question. And the agency has already taken a very clear position on how to read the statute. He's arguing they're wrong. That statement is wrong. So if you adopted that, we'd have an entirely new case before us.
We would, but I think, Your Honor, there's other paths of decision. There's other possibilities the court shouldn't foreclose. For example, the question of whether to do single risk determination or to do risk determinations use by use. The agency might have a third path. The agency might, on remand, decide that it's perfectly consistent with the best reading of the statute to do that on a case-by-case basis and not make a decision in a framework rule, which is what's before the court, that would kick that underlying legal dispute out of this context and would have to be resolved on a case-by-case basis.
Yeah, it's a different case
It'd be a
than the
different,
one we would be holding in abeyance.
well, at that point, that issue and the other issues, the parties would have to
So you would be
evaluate.
saying a couple of years from now, we've gone through all of this and we've changed our mind, we've altered, and we have some new ideas, so you don't need to hold it in abeyance anymore. Could you please dismiss it and we'll refile, and could you set a briefing schedule? That's what you want.
Well, that is one possible outcome. And
I don't see any other possible outcome unless you're prepared to tell us, no, we mostly accept what we've done. We just like to read it one more time in case anything occurs to us, but we don't see any major concerns.
well, I'm definitely not prepared to say that because I don't
Oh,
want to
you're not.
prejudge what the agency
No,
is
and
going
that's
to
why
do.
I'm saying the distinct possibility is 2 to 3 years from now, you'll come back and say, well, we've reconsidered. It's an different rule, different rationale, different reasoning, different administration. And so can you start briefing again?
Well,
And why isn't it a perfectly appropriate approach? Cases before us, it has been filed, been proper challenges, interested parties, the agency's position is on record. For us to decide with respect to certain statutory provisions, you're right or wrong in your assumptions. And then as you go forward and do whatever it is you want to do in a new regulation, you'll have those legal readings in front of you. Then you can set up any framework that you want.
well, a couple of reasons, Your Honor. One, the agency has committed to doing it in a year. So the time frame, we're not talking 2 to 3 years, but putting that aside, the statutory
We
questions.
can really hold you to that commitment.
Well, I mean, that's the agency's, that's what the
Can
agency
we
says. in its word.
reasonably, given practice in this area, we reasonably going to be able to hold you? We'll see you here next March 1. You really believe that?
It won't be March 1 because there will need to be time for the parties to evaluate what the agency
Yeah,
does.
exactly. So we're already into a year and a half, so we're past your year date. That's not a reasonable supposition.
The other point, Your Honor, is that on 3 of the 4 issues, the parties are not, there's no adversity. The government has not withdrawn its brief. We're not saying our position is wrong because we're saying the agency wants to take another look at it and hasn't formulated a position. That's different than confessing error, which we're not doing, but the court.
All we would be doing then, if that's right, is saying, okay, you're right, assuming we're going that way. You're right. Now go ahead and do whatever it is you can do with the law now having been clarified. And let's say, based on your current supposition, we agree with your interpretation underlying. Now, if you want to change the frame in a way that's consistent with our best reading of the statute, help yourself. But why would we waste time doing it otherwise? You're right. You have not withdrawn. The government's position is before us. And it is a subject of a dispute. There's no question it's a subject of dispute. No matter how the industry frames its argument, they are clearly disputing heavily on some critical points that go to the best reading of the statute. We would resolve that. Then you can do whatever you want to do.
Well, the place I disagree with you, Your Honor, is the government's position is not before you. That the government's.
I'm sorry.
The government's position is not before you because the government's position is not what's in the brief. The government's position is that the agency wants to reconsider and that the
No,
court.
the government's position is before us in the regulation and the support of the regulation. There's no doubt that's here.
Well, the regulation is definitely on the books, but I think it would mischaracterize the government's position to say that we are arguing our brief. We are not arguing our brief. We're saying that is not the current position. I don't know what the current position is of this agency because the agency hasn't had a chance to reconsider. So that's why we say it's not adverse, because the one petitioner that's bringing 3 of these 4 issues wants EPA to take another look. EPA wants to take another look. So the government's position is not actually before the court.
So let's suppose we grant your motion and hold the case in abeyance. We stay our hand. We don't issue an order of remand. We just hold it in abeyance. EPA in about a year promulgates a new rule. Someone with standing challenges that rule, either from the industry side or the labor side or the environmental side, some side. What happens then? Because they have to file a new petition, right? What happens to these petitions? Do we
That's what I was just
consolidate the new petition with these petitions? Then we figure out which arguments are moot or not, or whatever. How would we proceed?
I think that's right, Your Honor. And I don't, procedurally, I don't think that's unique. I think anytime a case is in abeyance while the agency is reconsidering and we get a new rule, if the old petitions haven't been dismissed, if for instance, party challenging it wants to reserve its ability to challenge the 2024 rule, well, let's say 2024 rules in effect, there's a 2026 rule. Party challenging the 2024 rule doesn't want to withdraw its petition because what if that 2026 rule is held invalid? 2024 rule comes back, party doesn't want to say, well, now I'm out of time, that's not fair. Let's keep that challenge in abeyance, but live so it can be restarted if necessary. So the challenges to the 2024 rule still on the book, still before the court's not doing anything. We get the 2026 rule, we evaluate. Yeah, I think it'd be consolidated. This court seems like the right venue for the new petitions, and we see what's a live issue and how the various stakeholders play out. Maybe there's different stakeholders, maybe there's not, maybe they're on different positions. We see what the agency's considered opinion is on the statutory questions, evaluate the record, and go forward. So that is how I would envision this taking, however long it takes, that would be the process. And
how should we factor in that Congress put the 1-year deadline in the statute for the administrator to establish by rule a process to conduct risk evaluation? And they said that, you know, not later than 1 year after June 22nd, 2016. And if we proceed the way that you would ask us to, we'd be, you know, at least a decade after that. Maybe that's okay for government work, but it seems problematic. It seems contrary to congressional intent.
Your Honor, the reason I don't think so is because EPA met the deadline. EPA issued the risk evaluation framework rule back in 2017. There's nothing in the statute that says that limits EPA's ability to reconsider that to issue a revised framework rule, which is exactly what EPA did in 2024 to do it again in 2026. The statute has an initial deadline, but says nothing about subsequent revisiting it, a deadline to revisit, or a time frame to revisit. So I don't think we'd be constrained by the statute. The agency is not constrained by the statute if it wants to revise the framework rule.
But has there been, I guess, the risk evaluation is the first step, right? And then there are actions that are supposed to take place based on risk evaluation, right?
Right, risk management would be the actual regulating the uses.
And has that occurred yet? Or has that been stymied by all of the court challenges?
EPA has issued risk management rules. That is not, that process is not halted. EPA has made risk determinations. So you complete the risk evaluation phase by making a determination and gone on to risk management and has issued risk management rules, some of which are being challenged.
But I guess what I'm trying to understand is then what happens to the current risk management rules while this is held in abeyance?
Well, those would be, while this is held in abeyance and while EPA is reconsidering, EPA would continue, EPA said it will continue applying the 2024 regulation. So those regulatory actions would continue to play out, any litigation would continue to play out. Once EPA has a 2026 regulation, then in issuing a new regulation, one of the questions EPA will have to answer is, what's the retroactive what's the applicability of that depending regulatory decisions? EPA did that in 2024. There's one part of the 2024 regulation says that it's not retroactive and that EPA is going to apply this 2024 framework to the extent practical to things that had already started. EPA could decide to do the same thing in a 2026 regulation. So not only is the substance of the new regulation unknown because EPA hasn't done that, but how that would affect pending risk evaluations is unknown, and EPA will have to think about that.
All you're saying that would happen here is that if we don't hold it in abeyance, you get a ruling from the court, the same rules would be in effect to the extent that the court doesn't disagree that there are legal problems with certain of the rules. And if we do hold in abeyance, again, you would continue to apply the existing rules. So the only thing that would be added if we go ahead and take a case that's properly before us is the court's input where we are permitted to have input. And under Loper, that would be in the places where there's a best reading of the statute to be offered. We would offer that. Otherwise, you'll be doing the same thing, according to you. The rules would be in effect only changed if our best reading of the statute, say, for example, is more consistent with the industry argument than what is on the table right now. But otherwise, you're saying we go ahead with this until 3, 4, 5 years from now when there's a new regulation. You can always start notice and comment rulemaking. Agencies always do that. But you're not proposing, there's no justification that you're offering for us not to proceed to give an answer to the legal challenges that are before us. I'm just not seeing any answer whatsoever. And it can't be about convenience because you say you're going to enforce the rule the way it is right now.
Well, what we think is missing is if the court proceeds to the statutory questions, it would be without the benefit of the agency's interpretation.
So, I mean, respectfully, that is not true. The agency on the record is on the record on why it did what it did. And I understand what the agency's position is on each one of these issues because they've stated their position in promulgating the rule. That's no mystery to us. And that's just not an answer because every time an agency says, well, let's have another notice and comment rulemaking, that can't be a reason to stop everything because agencies always have that authority to say we want to have a new notice and comment rulemaking. And our approach should be, go ahead, do your thing. That's not our responsibility. But if we have a case that's properly before us and it's raising legal issues that were properly raised, and they're here, and there's nothing to be gained here because you say we're going to keep going with the same rules. I just don't get it.
Mr. Durkee, it seems, is the government backing off of its position that there should be a remand of the rule and focusing on abeyance?
Well, Your Honor, I think the 2018 USWAG decision still supports what we asked for, a remand and an abeyance. I think that's solid precedent for that request.
Well, I mean,
But
in the
I think as I said before, if the court doesn't want to follow that precedent, I think the relief of abeyance would allow EPA to weigh in, which is what we're asking for. But I'm not
the abeyance
completely.
standards are much more amorphous than the remand standards, arguably. And I mean, one thing I'm surprised you haven't said is that, I mean, it has been this court's practice to regularly hold rules in abeyance after a presidential transition. They did this when President Biden came in and also when President Trump came in. We've overwhelmingly, we have granted those motions for abeyance.
Abeyance, not of the rule, abeyance of the
Abeyance
petition.
of the petition,
Right.
but not a remand. But the abeyance
Well-
is granted while the agency moves ahead with a new rulemaking.
Well, and Well, we've asked for abeyance twice, actually. We asked for abeyance initially for the agency to consider whether or not, to decide whether or not it wanted to reconsider, whether this isn't one it wanted to take another look at. And now agencies made that decision, and we're saying, hold it in abeyance and let the agency do that work. And again, we think a remand without vacature to allow the agency to do its work is appropriate and fits within this court's precedents.
But you don't really need that if we hold the petition in abeyance.
Well,
Pending a new rulemaking. Do
right,
you? Do you
well-
need a remand? I mean, the EPA can always move ahead with a new rulemaking, can reconsider its old rules. What does the remand
I think,
add to, say, an initial year-long abeyance?
well, I think that gets into the reasoning behind USWAG and other cases that award that relief. And again, I think the agency can accomplish what it's asking for without the remand. I think the remand is not exercising the court's authority in this case, because I disagree, Your Honor, that the statutory issues are not properly before the court. Three of the four issues are solely brought by a petitioner that has said they are not interested in proceeding. The fourth one, as we explained, it's not ripe. So I don't think the statutory issues are properly presented. I think the court prudentially should stay its hand until they are, until the agency has a chance to weigh in. And given that, I think there's procedural, there's agency procedural reasons why the court should stay its hand. It's not just a matter of waiting for the agency to articulate what it feels is the best interpretation for the court to give whatever weight is appropriate. Notice and comment rulemaking is the best way for the agency to proceed and to do so before the court weighs in. If notice and rulemaking comment, not just on the merits, the substantive, arbitrary, and capricious questions that we're talking about PPE and things like that, but on the statutory interpretation, to articulate in a proposal what the agency thinks is the best interpretation, to receive comments, to consider those comments, and to present it to the court. That's a valuable process that the court would be losing if the court went ahead and made a decision based just on the 2024.
Wouldn't be losing it, counsel. You've already gone through it. It's been done. I realize that we live in a strange world where change of administration has come to mean enormous things that I'm not entirely clear on, but it's still the same agency and it's still the same law and there's still the same public interest. And so the agency folks who are doing this work, I don't assume that they've all disappeared and that what they've done for the past 5 or whatever number of years has no meaning. It's not like the agency has no memory, history, legislative history. It's all there. You've done it. And so at appropriate time, parties can challenge what you've done because you said, okay, it's ready. You, the agency, has said it's ready to be done, challenged, because we've done our rulemaking, which the law, which Congress said, this is the way you do it. They've challenged it. It is properly here. They haven't written anybody, so far as I know, and say, we have no interest in this. We do not challenge the agency's position here. You want to do that. They want to submit something and say, we do not challenge the agency's interpretation. That is before the court. We accept it. That's a different thing. They haven't done that. They're just saying, we'd rather you didn't go ahead. It'll work in our interest, we think, if you kind of stay your hand and let things sit. They submitted a piece of paper signed and said, we are bowing out. We concede. EPA is correct. Because EPA is on the record. Whether you like that or not, they are on the record with this regulation. And if they came in and said, we concede, then you're right. Then you can go do your rulemaking or whatever it is you want to do. And the court then could think about a different kind of a case. That is, well, the one contesting party, one of several, one contesting party has said, we concede. We have no dispute. They're just saying it's not convenient for us to have a dispute. So can you take that, Your Honors? I don't know why we have to do that.
Well, Your Honor, I think the reason is to follow the precedent of the.
Now, I know what
case.
you're saying. It is not a mandatory rule. Judge Rao has been raising that is not mandatory. We sit here for a reason. We're supposed to think this through. We take it very seriously. And we're sitting here wondering why. They have not conceded your position.
True, but
So they have a dispute. You know why I know that? Because they filed and said we disagree. And the filing didn't say we agree with EPA.
well, Your Honor, I agree. It's not a mandatory rule on the court to remand or to hold in abeyance. It's purely the court's discretion. But I think this case is all in all fours with the USWAG case. That doesn't say, now the USWAG, you're right, the USWAG case, the solid waste case doesn't say the court must hold a stay at hand. But exactly the same facts are present here. We had industry petitioners that have challenges to a regulation. They've said they agree with the remand and abeyance, and environmental interveners disagreed. Labor petitioners didn't weigh in on 3 of these 4 issues. They confirmed that when they stood up here. So the case is on all fours with USWAG. Granted, USWAG is not a directive that the court must do, but I don't see a way to distinguish how the court would reach a different action here. And in fact, there's good reasons why the court should follow the USWAG precedent and not just hold an abeyance, but go ahead and remand.
What's the good reason?
The good reason is because that the agency, well, because the agency hasn't, I know you disagree with me, Aaron, but the
No, I don't
agency.
know what you're going to say. What's the good reason?
The agency.
I can't figure it out.
The agency has not articulated its view of the best
Go
reading of
do
the
it.
statute. Well,
Go do, you have the right to have notice and comment rulemaking again if you want to. Go do it. That's not a reason.
well, the reason is, Your Honor, we think the court should wait for that.
Why?
Well, the court doesn't have to wait, but that leads to better decision-making. That's consistent with Loper. Loper didn't remove the
We're going in
agency.
circles. I mean,
Well-
years and years keep passing. We're forgetting that Congress said something to start all of this. They had some requirements. I don't think they were contemplating, let's go for a decade, see if we can come up with something.
Well,
But I won't.
well, let me go back to the 2017 regulation where these statutory issues were not joined. The Ninth Circuit in the Safer Chemicals had this similar issues before it, where the question was the challenge to using a single risk determination and the challenge to excluding conditions of use at the scoping stage. And based on the 2017 regulation, the court said they're not right. We're not going to decide. The agency should be able to make the decision before this court weighs in, whether one possible decision point is maybe they go back to the 2017 regulation framework and don't speak to it. And in that case, it would be improper for the court to, well, I wouldn't say improper. The court will have ruled on something which now the agency has taken away and said, that's not our
Oh, we
regulation.
wouldn't. At least in my mind, I cannot imagine us ruling on anything other than the statutory questions that
But the
the
statute,
Supreme Court has said if
The
it's
statute-
before us should be,
but
can
the-
be litigated.
well, but the statutory questions might no longer be live after the remand after the remand and the agency
And you would
reconsiders.
take that into account as you're doing a new rulemaking. You say, well, you know, that's what the court said, but we're doing it a different way. That's fine.
The court definitely has, again, I'm not denying the court's power to do that, saying the court should
Well, your
stay its
power to
hand.
do that. We would just tell you, given the challenges before us, the agency's position and the challenges to it, here's what we, best reading of the statute is, where that is appropriate. And that would be it. Then we're done.
Right. And the agency's position is the court should wait for the agency to weigh in on that. This Loper in abrogating Chevron, Loper didn't say ignore the agency.
No, I'm not saying Loper gives us an answer on what we're chatting about now. They give us an answer with respect to our role when legal challenges are properly before us.
Right. And the agency's position is the court should stay its hand in exercising that authority until the agency has a chance to reconsider, weigh in on what the statutory interpretation questions are on the ones that industry is not pressing as well as the one labor is pressing. And at that point, make a decision, as Judge Wilkins said, after the procedural chips fall more than.
What's your position on whether we can, or A, or B, whether we should sever some of these issues, hold some in abeyance, but decide others.
The government's position is that the court should keep the case together and hold and stay its hand on all the issues. But we recognize that the three issues that industry is the sole petitioner on require a different analysis than the one issue, the PPE issue. Now, we think the outcome is the same on all four of those issues, and therefore it's appropriate for the court to stay its hand on all of them. But the analysis is different because of the one issue we talked about earlier, the statutory question of what does it mean to be a non-risk factor? Does that include PPE or not? On that one, we say it's not ripe and that the labor petitioners are not injured or not prejudiced if the court stays its hand. But that's a different analysis than the other three issues where we're saying, well, it's not, there's no real adversity.
There's no real adversity because you're no longer defending what was said in your brief.
And because industry petitioners on those three issues are the only petitioners challenging it. Labor is not challenging that, and environmental parties are interveners. And that takes us back to USCA. That's exactly what happened in USCA. And the court remanded and held in abeyance. And that's what we think is the appropriate remedy here.
Just had one quick question. Is the government's understanding is that Loper Bright does not change this court's traditional discretion over abeyance? Is that correct?
Yeah.
That Loper Bright does not affect our ability to grant abeyance when there are statutory questions raised?
Right. Loper Bright on its face doesn't talk about that.
No, of course.
And
but-
I think it doesn't affect it because Loper Bright, well, environmental interveners, when they stand up, they might make this argument because it's in their brief. They say the court should interpret statutes as if the agency wasn't here. We think that's not right. We think that's a misreading of Loper. There's still a role for the executive's view for the court to consider. It's not binding, obviously, on the court, but there's a role for the executive agency's statutory interpretation. So because of that, I think Loper doesn't disturb these traditional practices and the ability of the court to remand pending the agency's view on statutory interpretation. If environmental petitioners were right and Loper just completely cut out the executive, then I could see an argument why there wouldn't be a reason
Well,
to
it's
wait.
not just cutting out the executive, it's also an argument that it affects our discretion to hold a case in abeyance.
Well-
They're two, there's an Article 2 question, there's also an Article 3 question.
Well, I think
And your argument is that it doesn't change either the Article 2 involvement or the Article 3 discretion to hold an abeyance.
right. I think the Article 3, there's still respect owed to the executive branch, and the court should wait and get the implementing agency's considered decision. On the Article 3 side, the court clearly has the power to make the statutory interpretation. Like Judge Edwards said, we're not saying you can't do it. We're saying you should stay your hand and not do it and wait because of the Article 2 concerns.
Thank you.
Thank you, Your Honor.
All right, thank you. We will now hear from counsel for respondent interveners.
Good morning, Your Honors. My name is Tosh Sagar on behalf of the respondent interveners in support of EPA's final rule governing this risk evaluations. On remand, I think you heard EPA and industry say that abeyance is not mandatory. It's discretionary and prudential. Our view is that after Loper Bright, it makes little sense to remand statutory issues back to the agency, whereas here it would be their third bite at the apple. In those circumstances, right, you've heard from the agency, you have their briefs, giving them another shot, I don't think would inform your consideration of the issues.
Loper Bright says we give due respect to executive views, right, and agency views.
Relative to the consistency of the agency's interpretation here, it would be their third switch if they were to take a new view. And so I don't think.
Doesn't mean we automatically give it no respect. We just give it whatever respect it's due. Maybe it's not due as much as if the agency had the same view for 20 years, but that doesn't mean that it's due no respect or that their views are irrelevant, does it?
I don't think we've argued that it's due no respect. I just think sending the statutory issue back to the agency for yet another bite at the apple won't really help illuminate the issues or the court's consideration of in deciding those statutory issues. You had asked sort of procedurally how it might work. I want to note that I think it would create a bit of a procedural morass. Unlike other statutes here, petitions for the next rule can go to any circuit court, and indeed both framework rules, the 2017 and this one, there are multiple petitions in multiple circuits that are consolidated by a lottery. This petition, these sets of petitions were consolidated and sent here. It's entirely possible that the next set of petitions would be sent somewhere else, and you'd have one petition here, one petition in another circuit. I think that's another reason that counsel's against sending this back to the agency. I think Judge Edwards, you noted that you can't hold them to the timelines. I think that's exactly correct. I think this court's practice shows that remands or holding things in abeyance for the agency to sort of do a new rulemaking doesn't.
Suppose for the sake of argument that we were inclined to find either that the labor petitioners don't have standing or that their challenge is not right. And so the only challenges that would be validly before us would be the industry petitioner challenges, and they are fine with abeyance and or remand. If that were the case, why go forward? Because the only parties that we would have jurisdiction to rule in favor of has told us that they're fine with us deferring, and they want to see what the new rulemaking generates. Because you're not asking us for any relief other than to just uphold the rule, right?
Well, I would say two things. In that circumstance, if you're just talking about abeyance, formal adversity remains. I think, as this is Judge Edwards' point, they're just saying it's not convenient for us. They, being industry, would be saying it's not convenient for us to have a decision now. That doesn't eliminate the adversity that's here, and there is a true case or controversy that remains. I think my second point is that also distinguishes this from USCA, where there was a true level of sort of absence of formal adversity. And so, I think they kind of want to have their cake and eat it too, is how it feels to us. They want this petition here. They want you to hold on to it for however long it takes till the agency gets to a new view. These are statutory questions that have plagued this statute since the day it was enacted and amended in 2016. And it's this court's role to say what those statutory terms mean to set the rules of the road for the agency. It keeps flipping back and forth. That's having real practical consequences on the ground for chemicals that people are exposed to. I'll just give you one example. 1,4-dioxane, the agency started it as one of the first chemicals in 2017. It's 2025. We don't have rules. We should have gotten rules in 2022 for this chemical. And we don't have them because the agency has to change its analysis between administrations to, like, the first under the Trump administration, they excluded a bunch of conditions of use. The Biden administration came in, said that's illegal. They added a bunch of conditions of use, found that the chemical was contaminating drinking water throughout the country, causing really severe risks of cancer. They issued a final risk determination in 2024. That's now being challenged, the supplement, in a court because industry is saying you can't issue this supplement. I mean, this kind of this is a procedural rule, as Your Honor noted, that should have been finalized in 2017 to set the rules of the road. And the uncertainty that remains is causing havoc in the administration of this program. So I think the prudential concerns that again, they admit that this is a prudential decision, suggest deciding this case here. With that, if I could turn to the merits, unless there are any questions on remand itself.
Why don't you turn to the merits?
Thank you. Starting with the all conditions of use argument, I think your colloquy with my friend from representing industry confirms that their position requires reading into the words into the statute. The statute doesn't say only consider the conditions of use with the greatest exposure potential, and that violates a cardinal canon of statutory construction. That's this court's decision in Neely. Congress wanted comprehensive risk evaluations that included all activities from initial manufacture to ultimate disposal, everything in between. That's how it's defined conditions of use. And they want piecemeal partial risk evaluations. I think there's maybe a concrete example I could give you that illustrates just why their industry's petition can't be correct. So if you imagine a small baby that's exposed to a widely used flame retardant, the flame retardant is in the baby's crib. The flame retardant is on the rug it crawls on. It's in its toys. To understand the risk the baby faces from this flame retardant, you need to look at all three. You need to be able to look at the combination of all three to understand the baby's total exposure. Industry's interpretation would allow EPA, before it conducts any analysis, to exclude one or all of those and thereby miss the exposure the baby faces. It would also frustrate, and this is more on the single determination whole chemical, it would frustrate EPA's ability to look at the combinations of those three activities to see the total exposure to the baby. There's no way to look use by use and understand, oh, the baby's exposed to the rug, that's too small. The baby's exposed in its crib, that's too small. But that's what industry's interpretation would require. That's contrary to the text, which requires determinations on the chemical substance, that requires EPA to protect against any combination of unreasonably risky activities. My friend representing industry, I think.
Now, just to be clear, your friend on the other side would say, well, you can consider all of those different uses at the risk management stage.
But
say that under the framework, the statutory framework, that doesn't work because it's too late.
exactly, it's too late. The statute requires, and this is 2605 B4F, there's a requirement to assess the exposures under the conditions of use. And Your Honor, I can quickly give you, that is at addendum, the industry petitioner's addendum at 12. So this is 2605 B4F. It says EPA shall assess available information on exposures for the conditions of use. That's B4F little I. I believe there's another provision. There are five of these. If you don't mind, I'll just pull it up myself.
It's the one that also says
Is-
describe aggregate or sentinel exposures, et
It's-
cetera.
Yeah, and then just below that in IV, it says, take into account the likely duration, intensity, frequency, and number of exposures under the conditions of use. That's required. Those are all and this subsection is entitled requirements for a risk evaluation. That's all required in the risk evaluation stage to look at how much exposure does a baby face from a rug? How much exposure does a worker face in the workplace? How much exposure does a fence line community face breathing air that's contaminated by the nearby factories? And so you have to get that exposure analysis right to understand. And I think to understand, okay, here's the harmful dose of a chemical. That's hazard. Where's the exposure? Is it above? So there's risk. Is it below? So that there's not. That's what this stage risk evaluation requires. And what they want to do is take out pieces that contribute to exposure, allow EPA to remove those from the equation so that EPA underestimates exposure. And then you cannot take that back into account on the back end at risk management.
Then what about your friend on the other side and says, well, then obviously you need to consider PPE because PPE affects exposure, right?
We have not weighed in this litigation on PPE, and I'm not authorized to state
So
it.
you're not going to defend the EPA's rulemaking position, PPE?
We've not taken a position.
not-
We're not going to, and I do want to note one thing though, on every other issue that industry raised, we are defending in EPA's rule, and we adopted EPA's arguments. So EPA's arguments today, I think I heard my friend Mr. Durkee say, you know, we're not standing on our briefs. That's irrelevant. We've adopted those arguments expressly in our brief and so those are all fully presented here. On the whole chemical approach, I think you heard my friends from industry say over and over again that there's no analysis of the individual activities, and that's a problem, and that's just wrong, both as a matter of the statute, EPA's implementing regulations, and practice. And if I could point, Your Honor, just as a matter of sort of practicality, looking to an actual risk evaluation, this is at JA 387 to 451, where you can look and you can see how EPA looks at each activity and looks at the exposures faced by consumers, by workers. It looks at different scenarios, different products, each condition of use, and it analyzes, okay, how much are people exposed? And that's what drives EPA's assessment of risk. And EPA in its regulation says, we're gonna look at the exposures for the conditions of use. We're gonna compare them to the hazard level, and then we're gonna make a risk characterization for the conditions of use, and they do so. And then at the end, they say in their regulations, and again, this is the final regulation, 702.39 F3, EPA says we're gonna identify the conditions of use that contribute to the risk determination. So those ones that are above the threshold for risk, we identify them, and they necessarily identify those that don't. And that feeds into the risk management process. EPA knows which ones are risky, which ones aren't. Again, I'll give you a specific example. This is at J8385, where they identified those that they knew to be risky and those that they knew not to be risky. I think we pointed this out in our briefs. They had nothing to say on reply because there is no answer. EPA does exactly what they claim EPA should be doing. And that's another reason their whole chemical argument fails. If there are no further questions on the merits, I would just say, again, these are basic statutory requirements that EPA has been flip-flopping on for a while. It's causing real harm. It means that protections are not being put into place. It's this court's job to say what the law is, to clarify the rules of the road. There is real formal adversity here, and prudential reasons counsel on deciding the case before the court. Thank you.
Thank you. So we'll hear rebuttal from Mr. Ballinger.
Yes.
Let me just say one thing before you start, because you can attend to it if you want. On your side, I guess, on your side of the argument, utility solid waste was cited as a reason justifying or not deciding anything.
Yes, sir.
That's a case in which there was a new statute that was enacted, and it might affect the agency's regulatory approach, and that was the court's justification. That's not this case.
There's nothing like the WIN Act, which I believe you're referring to in the USCA case, Your Honor. I'm not aware of anything that would serve that same function in this case, no.
You're not aware of what?
Of any new statute that would serve the same function.
No, there isn't. And so it's a little annoying to hear that citation being the justification why we would let this case go. It's an entirely different situation if there's a new statute that's been passed. Unless I got it wrong on solid waste.
Certainly, Your Honor, and if that case does not guide the court's judgment, then I understand that. Good morning, Sam Ballinger, Your Honor, for presenting the joint rebuttal. My time is short. I will make just a few quick points to follow up on prior discussion. Even after Loper Bright, this is not simply a matter of when the court addresses questions of law. The court does not address questions of law simply because they are questions of law. The court addresses these issues because there's a petitioner who has standing who brings a ripe claim to the court. Today, that is the labor petitioners file against PPE and the industry petitioners file with the broader challenge addressing with the broader challenge. And those challenges are before the court now, but what the agency does on remand may address those concerns. If the agency promulgates a new rule, it is entirely feasible that the petitioners currently have standing, bringing their claims, are satisfied with that and go away. And so there would never be a matter before the court. There would never be a ripe matter for the court to adjudicate because those parties may get everything they want to out of the amended rule. And that certainly does happen when an agency takes the rule back under reconsideration and it arrives at an outcome that is acceptable to everybody. Now, obviously, other parties may subsequently take issue with that rule, but then they would have to show standing and then they would have to show ripeness in much the same way. So it's not simply a matter, even in a Loper Bright world, it's not simply a matter of when the court inevitably addresses these questions. It's a core issue of the court's adjudicatory authority for when and how it does in fact address these questions. And so that, I think, is one of the essential distinctions that justifies the abeyance in this case. And Judge Rao, you asked earlier about the authority of the court to issue the remand. I would point the court to section 2816B, which authorizes the court to send the matter back down to the agency for further review. And if that does...
What provision was that?
Pull it up here. Please. 2618B.
Of Title 15?
Yes, Your Honor.
26.
It's lengthy. I won't bother to recite it fully to the court. But what I would like to note is that to the extent the remand issue is a concern, I do think an acceptable compromise might be a 12-month abeyance, as we discussed earlier, which would serve similar function in this case. So, but if the court does, the one other thing to emphasize as well, and I apologize, is that what the agency does on remand, it will issue presumably a new rule, but that rule, the scope of that rule is different. The agency would have the authority to distinguish between what it addresses in the framework rule itself and what it leaves to adjudications under 6A in individual cases in the future. So the agency will presumably issue a new framework rule, but the scope of that is not necessarily on all fours with the current presentation of the case. And that's one reason that holding this case in abeyance makes sense, to preserve these challenges and to ensure that this rule does not evade review in the event that there's any change in the scope on remand.
Counsel, I hear you saying there are things the agency might do. Yeah, of course. Anytime an agency decides to engage in new rulemaking, there are things they might do that look different than what they had previously done. That's old news. That's not a justification for our leaving a case that's properly before us for no apparent good reason. A good reason can't be because the agency might do something different, especially when they're not even suggesting where they're really worried about anything. But in any event, we got a case that was properly presented, challenged, and it's probably before us. And the agency still has the right to go through rulemaking, which they say they're going to stay with this rule anyway and go through rulemaking. So I don't know what the gain is. The only gain would be to the extent there have been legal issues beating a dead horse that have been around for almost a decade. The court is probably being asked to answer some of those questions, and we have the authority under Loper to do it. We can answer them. They may or may not be relevant in the new rulemaking.
Your Honor, I understand what you're saying, but I do, I would respectfully disagree that it's as simple as it's a pure question of law under Loper and it's within the court's power to adjudicate, and so it can do so. The issue, as I said before, is that the court should do that in the context of having a ripe claim by a petitioner with standing. Earlier, we discussed the deficient showing by the labor petitioners for standing. And in that regard, too, I would like to highlight footnote 13 of their brief, where the labor petitioners admit they don't actually know whether or not this rule would be applied in this way at all, as they fear, which would seem to indicate that, a difficulty with standing in that case. But I don't agree, Judge Edwards, that the matter is so simple and that the court should address the questions of law because they are presented here today. This court has routinely stayed its hand and allowed an abeyance when an agency indicates its intent to reformulate these issues, and on reformulation, the scope of that may change because the agency can divide between a Section 6A final rulemaking in the context of a given chemical and what it addresses in the framework rule. As for example, PPE might be something that is not just period in the framework rule, but might be addressed more concretely.
Nothing that we would say would foreclose that possibility.
That is likely true, Your Honor.
That is absolutely true.
Yes.
Unless the agency did something that was positively unlawful. Nothing forecloses the possibility that the agency would, we have this whole new different approach. We're going to use this framework and that framework and ideas that have never been thought of before. And my attitude still is help yourself. But we have a case before us, we decide it and we move on.
Certainly, Your Honor. And I understand what you're saying. I still think that the matter of when it arises and the scope arises matters and justifies prudentially, if not requiring at the moment, staying in the court's hand. But I understand what you're saying, that these are essentially questions of law that will be before the court.
Do any of the industry petitioners invoke 2618B? Because that's a very specific procedure for additional submissions and presentations and modifications.
Your Honor.
So it doesn't talk about abeyance or remand. It says that if either a party or the administrator wants to introduce new submissions or presentations, then the court can order the EPA to consider that. And after that order of the court, then the administrator may modify or set aside the rule or, or make a new rule. So is anyone actually invoking 2618B explicitly? Because that does seem to be a mechanism, but I don't recall that being in the briefing. Perhaps I missed it.
Your Honor, I believe you are correct that no party explicitly invoked 2618B or attempted to make a showing or address that statute as it is presented, but it does.
That was just the justification, though, that you gave for the remedy for the abeyance and remand that you are seeking. But this is a whole different procedure that might actually give industry petitioners and EPA what they are seeking, but I don't see where this has been sought.
Well, Your Honor, if the question is simply the court's authority to remand to the agency, setting aside the abeyance question, if the question is the court's authority, then I would submit that that does provide the authority to the court.
Well, it provides the authority if a party seeks to make additional submissions and presentations, but that's not what either EPA, perhaps EPA could say, we'd like to make additional presentations and consider more information, please send it back to us. But I don't see anything from EPA making that or from industry petitioners. Maybe that's still something that is available. I'm not sure if there's some sort of time limit, but that seems to be an avenue that hasn't been tried.
No, Your Honor, and I don't mean to say that the issue has been fully briefed or fully
briefed at all.
Hadn't even been raised.
Correct, Your Honor. But neither has the authority of the court to issue the remand been as addressed in the papers. I offer that simply as a note for what the court has had the authority to do.
I'll accept that as your understanding of the concerns that we're raising. But that answer that you're offering really is inapposite.
Thank you.
I'm done.
All right. Give you a few seconds if you have any concluding.
Just my last concluding note would be to address the fact the conditions of use. The conditions of use, the reason the whole chemical approach does not make sense is because the essential relationship in the statute is the relationship between Section B4A and Section 6A. B4A defines the risk, which triggers the authority of EPA to regulate under Section 6A. And to the extent there's any ambiguity in what the scope of that risk evaluation is, Section 6A answers that question by saying very clearly that it is the manufacturing, it is the processing, the distribution of the chemical which presents that risk. And it presents that risk in the context of a given condition of use. And so, Judge, I would agree with the notion that the agency's authority to regulate is based on its finding of a condition of use, of a harm within the condition of use, as carried through in that relationship between the two.
Thank you.
Thank you.
All right. Labor petitioners?
I'll be brief. I'd just like to briefly address the claim that our petition is not ripe. The law in this circuit is that a facial challenge to an agency policy is presumptively ripe if it raises purely legal issues, and prejudice would result from delaying a decision on the merits. Here in USWAG, the court found that the parties would suffer prejudice if a remand caused a failure to vindicate our claim. The same thing would be true here. And a delay also means that many of the risk evaluations and many of the risk management rules that have been issued are presumably going to have to be reworked to conform with whatever is eventually decided, some court eventually decides TSCA means. And so we think that's going to result in a substantial proliferation of litigation on a chemical by chemical basis. And the other harm that befalls us, and this is the same harm that my colleague from the Chemistry Council mentioned, is if EPA moves forward and continues to consider PPE, the burden is on us to gather information from our members about PPE use and misuse and submit all that to the record, and then be prepared to challenge on a chemical by chemical basis what EPA decides if we're not happy with it. And as Judge Rao pointed out, while I think we have standing here, our members are not exposed to all chemicals in all uses. And so these issues may proliferate, and we may not be in a position to challenge what EPA does because we can't identify members who are exposed. So for all those reasons, we do think that a delay in reaching the merits would prejudice the labor petitioners. And I'd like to thank you for all your attention to this case this morning.
Thank you. We'll take the case under advisement. Let's take a 5-minute break.
Court will now take a brief recess. Stand, please. This honorable court is again in session. Be seated, please. Case number 23-7158. Alexander Gallo, appellant versus District of Columbia, a municipal corporation. Mr. Seedleck, amicus curiae for the appellant. Mr. Gallo for the appellant. Mr. Gerten for the appellee.
Morning.
Good morning, Your Honor. May it please the court. William Seedleck, court-appointed amicus supporting reversal. I'll reserve 2 minutes for rebuttal. The right to exclude is foundational to any conception of private property. As the Supreme Court has repeatedly made clear, government action eviscerating that right creates a taking under the Fifth Amendment. Here, for nearly a year and a half, the district both prohibited landlords from evicting breaching tenants and even barred them from initiating eviction actions in court. On the facts alleged, the district's moratoria created a taking for 3 primary reasons. First, as the Federal Circuit explained, by prohibiting the eviction of non-paying tenants, the government created unwanted occupation, private property. Second, this occupation indefinitely deprived the appellant of any ability to regain control over his property. And third, the moratoria prevented the appellant from seeking any remedies that could have led to his regaining control of his properties or receiving compensation during the moratoria's duration. For these reasons, the district court's dismissal of the takings claim should be reversed, and I welcome the court's questions.
Was the filing moratorium absolute? Did it have no exceptions initially for that first year or so?
For the filing of a summary eviction action, yes. And then eventually they did incorporate exceptions for willful or wanton destruction of property or potential danger to other residents.
For the filing.
for the filing moratorium, which that coincided with the same exception that was added to the eviction moratorium.
But there was no moratorium or bar to filing a civil ejectment action, correct?
So yes, for filing the civil ejectment action, that's correct. However, the eviction moratorium still would have prevented the actual suit from reaching a successful judgment, just because for any tenant, for any leaseholding tenant who would have been protected by the Rental Housing Act.
But how would, with respect to the foreclosure unit, how would that be construed properly for that person to be a leaseholding tenant? There was no lease.
Yes, there is no lease, and so I submit as an amicus that there's no takings claim as to the foreclosure unit.
Just like, assume we agreed with you about that there was a physical taking for at least for the delinquent units. What about, did Mr. Gallo state a takings claim in his complaint? Because it's not clear, arguably from the complaint, whether he was actually denied compensation.
So, Your Honor, if you actually look at the complaint, and this would be on A194, he does seek both a declaratory and what he calls nominal damages, $5 in nominal damages. And so even if the $5 were all that he were seeking, under cases like Loretto as well as Cedar Point, that would still be sufficient.
But something is not a taking if there was just compensation.
Well,
So that you haven't stated a claim. I mean, just because you're also asking for nominal damages doesn't mean you've stated a takings claim.
it's not clear that he hasn't, that he has foregone stating a takings claim for just compensation. Specifically, if you look at page A195, under claim 1B, he does have a statement that says, quote, "The taking is whatever the theft turns out to be." That could potentially be read to say that he's still seeking any potential payments that may not have been received in full, or even could potentially be for time value of money, perhaps, which would also be recoverable as a taking.
So we should infer from this language that he's alleging there was no compensation, or not in just compensation.
That there might not have been full just compensation, correct, Your Honor, in which case the claim could go forward, and then this would just become an issue for valuation discovery. And of course, we are dealing here with a pro se complaint, which of course gets liberal construction, and even Uzabunum itself says that the damages awarded by default will be the nominal damages or the requested damages stated, and if he proves that he's entitled to more, then that will be for the court to handle going towards the judgment. So speaking to the takings claim itself, we submit that the moratoria did give rise to a physical taking. If you look specifically at Loretto, it describes how a physical occupation occurs because the owner, quote, "The owner has no right to possess the occupied space himself and also has no power to exclude the occupier from the possession and use of the space." We submit that effectively is what happened here, because Mr. Gallo had no means of being able to remove his tenants for allegedly 6 months. And I see that I'm getting into my rebuttal time. Unless the court has further questions, I'll return on rebuttal.
All right, thank you.
Thank you.
Mr. Gallo, we'll hear from you.
Good morning or good afternoon. I'm Alex Gallo. May it please the court. I'd like to reserve all my time for rebuttal. So unless there's any pressing questions, I'll let the district proceed.
All right, just so you know, if rebuttal is meant to be rebuttal, so if you do that, you can only respond to anything that the district says. You can't raise any new points that haven't been discussed on rebuttal.
On that, then I'll just respond to amicus briefly. 3 things I'd like to respond to. There was a statement that ejectment actions were permitted under the moratorium. That was disallowed by the state court, both practice and an order. So the suit that was filed concerning the foreclosure unit was construed as an ejectment action by the state court in landlord-tenant branch and refused. The second point is the no formal lease agreement is true from an express contract perspective. It's not necessarily true from an implied contract perspective. And I did cite the Federal Circuit, I think it's called Niagara, that says when someone is in a house not paying, there is an implied contract for the rent. The third point is no taking if no compensation. This is a nebulous area. What I'm alleging in the complaint is that a declaratory judgment should still be ripe even in situations where the breach of lease was not for non-payment. So there are behavioral breaches, there's smoking in the unit, things like that. It's unclear what.
Mr. Gallo, did you receive compensation from the District of Columbia for the delinquent leases?
At what point in time is the court's question referencing? Are we talking?
Any point in time.
Yes, for some of the people, a year and a half after the taking began, what I allege, there was a rent relief program called Stay DC. It was created 1 year after the moratorium went into effect. So my position is where that compensation did come, it is unconstitutionally late and it wasn't provided with the moratorium statute. And no interest was provided.
All right. Anything else before we hear from the government?
No, thank you for your time. I'll return for rebuttal. Thank you.
Thank you. All right, Mr. Burton.
Yes. Good afternoon, and may it please the court, Jeremy Girton for the District of Columbia. The court should affirm the district court's dismissal of Mr. Gallo's second amended complaint, which fails to state a claim under the contracts or takings clause for multiple independent reasons. I think it makes the most sense to briefly discuss the areas where we agree with the court-appointed amicus before reaching the issues where we disagree. As to the foreclosure unit, the amicus and the district agree that Mr. Gallo has no viable claims on the contracts clause because he does not allege that he had a contract that was impaired, and under the takings clause because the ejectment remedy was available throughout the pandemic and throughout the moratorium's existence. So he still had a remedy to eject the trespasser in his unit, and he could have evicted that person at that time, but he chose not to take that remedy. I also note that he still had damages remedies also available throughout the pandemic as well. As to the other units, the amicus agrees with us that Mr. Gallo does not state a contracts clause claim, specifically because there's an absence of particularly pleaded facts about the leasing contracts themselves. That's from 26 of the reply brief. I think this goes to your question, Judge Rao, about whether we have enough information here to state a takings claim, because we just don't have any details about whether Mr. Gallo actually had leases with these individuals. And as he said today for the first time, that he actually was compensated after the fact. That's a new piece of information that we didn't have until today.
One of the things that I was thinking about is if we were to disagree with the district court about the contracts clause issue, whether you could have a contracts clause issue under 1983 or whether this was a physical taking, is the appropriate approach for us to send it back to the district court to let Mr. Gallo have another opportunity to amend the complaint? I mean, there are of course cases where we review failure to state a claim de novo. We could just dismiss the complaint. But I wonder where the district court, if we were to conclude that the district court had misunderstood the law, what's the appropriate?
Well, I
path
think,
for the
I think it
court?
would depend a little bit about the nature of the court's decision and what was misunderstood. But I think it's important to remember here that we're on the third complaint at this point. And after the second complaint, Judge McFadden instructed Mr. Gallo to provide additional details specifically about these other units that amicus says he has a claim about, and to explain what injury he suffered and what the details were about these tenants.
But I do wonder if, like, when an instruction like that is given, if the district court was misunderstanding the legal requirements, perhaps those instructions for how to amend the complaint are deficient, especially for a pro se plaintiff.
Well, I think all of Judge McFadden's decisions show a real care for the pro se pleading standard. But I also think that amicus agrees with us on the contracts clause claim completely, so I don't think that there's any potential error as to that. I don't think you need to reach the 1983 question, as we agree with amicus as well. So I think you can affirm on other grounds there. But as to the physical taking claim, and I'm happy to address the merits of that, I don't think there's any error there either in Judge McFadden's reasoning. He correctly identified that the Supreme Court case in Yee is what is controlling when you have a landlord-tenant relationship. And Yee says explicitly that the invitation to the invited tenants is what makes the difference between a physical takings claim and a regulatory takings claim. And it says the line which separates this case from Loretto, which is a physical takings case, is the unambiguous distinction between a lessee and an interloper with a government license. And in this case, the district was regulating the relationship between existing tenants who had been invited into the property and landlords. It was not inviting on its own new people to come into someone's property in the way that Cedar Point was dealing with. And it wasn't giving them the affirmative right to be present in the property without the obligation to pay rent.
Right. So my question is, though, if we were to disagree that Yee was the right framework and we thought that there was a physical taking, then wouldn't an amended complaint be necessary to state the elements of that physical taking?
I think they would, but in that case, you'd be sending it back regardless for further proceedings. So the trial court would be within its discretion to kind of decide whether it needed an amended complaint or not. I think even if you disagreed with the trial court and our reading of Yee, the current complaint does not have enough information to
Right. So my
make.
question is, should we say that on appeal here, right? That even if we, not reached, we just say there's a failure to state a takings claim.
Yes, I think you should. And I think there's a few key details that are missing here that are really important. One of them is that he does not allege whether or not he was compensated. Today at the stand, he said that he had been compensated by the district. So that's a really important detail to include in the complaint. He also doesn't allege clearly that he actually owns any of these properties rather than manages them. He doesn't allege that he had leases with the tenants that were bona fide such that they were actually covered by the moratorium. He does not allege whether or not the tenants themselves paid back any late rent or how much money that was. And I think those details are necessary because the district has to be able to effectively answer the complaint and respond to these allegations. And I don't think we can do that unless we understand kind of what properties are we talking about? What is the potential taking here? So I think even if the court were to disagree, I think it should state that the current complaint just fails to state a claim, and that he had 3 opportunities to clarify his allegations, and he was given specific instructions about how to do that, kind of irrespective of the Yee Cedar Point issue, and didn't provide those details. I would like to say one additional point about the amicus's argument about Cedar Point. I think amicus is really overreading Cedar Point to an extreme degree that would create real problems for other rental housing regulations. He said in his statement to the court today that it was about any time a landlord had unwanted occupants. But if the rule is that any time a landlord determines that their tenants are no longer wanted, that the government has forced upon them a physical taking, that would really eviscerate a lot of landlord-tenant protections, including the protections against non-discrimination, which are when a landlord doesn't want to rent a property to a tenant because of some discriminatory reason, that is still requiring them to lend their property to someone that they don't want to. And no one has ever said that that would be a physical taking. I think it would also take out all rent control statutes because those prohibit a landlord from charging a higher rent or to a different tenant who's willing to pay a higher rent than the current tenant. And I think it would also, and I think the Cato amicus brief actually makes this point quite clear that that is one thing that would have to fall from on pages 14 to 18. I also think it would squarely conflict with the Supreme Court decision in Block from 100 years ago, where the court allowed the district to extend leases during World War I. So that was tenants that the landlord otherwise would want to evict, but they were forced to continue having them at the same rate due to the emergency. And the court said that that was not a per se taking. So again, that would be in conflict with the rule that they're proposing today. And last, I would say it would also conflict with the Florida Power case, which is discussed in Yee, where the government actually reduced the rent that utilities could charge for leasing portions of their utility poles. So that wasn't even just keeping it at the same rate like Block, but actually the government reduced the rate significantly and still required them to allow the essentially tenants that they had already invited onto to use the property. So I think all of those cases would need to be overruled before the court could conclude that this was a physical taking.
Is it correct to read the filing moratorium as not containing any exceptions for that first year or so?
I think that is correct, except to say that the ejectment action remained available to everyone. It wouldn't have allowed someone, as amicus said, to actually conduct an eviction, but they could have gotten a judgment of possession through the traditional ejectment action, even for a traditional tenant. So that major exception of the common law ejectment action remained. But
what could they do with that judgment of possession?
So they could include in that a request for damages, so they could get a damages judgment as well that they could potentially collect on. They would have the judgment ready for when the eviction moratorium lifted. If they participated or at least applied to the Stay DC program beginning in October of 2021, they could have conducted an eviction kind of earlier than other landlords would be able to do so during the phasing period. So it did give them certain rights that would permit them to both regain possession of the property and get damages for any rent that were in arrears during that period. So unless the court has any further questions, we would ask the court to affirm. Thank you.
All right, we'll give you 2 minutes for rebuttal, Mr. Seidlich.
Thank you, Your Honor. Just a few points in rebuttal. First, with respect to traditional landlord-tenant regulations, we submit that what makes the moratoria here fundamentally different from traditional regulations, which would spare traditional regulations of the sort of takings analysis that this case would call for, would be the fact that under a traditional regulation, the landlord would still have the ability to seek an eviction, seek to remove a tenant for noncompliance with the lease. And specifically, if you look at the Second Circuit's recent opinion upholding the New York City's landlord-tenant rent control provisions, they actually discuss how it is well settled that limitations on the termination of a tenancy do not affect a taking so long as there is a possible route to an eviction. And here that possible route we submit was prevented for about 1.5 years. With regard to the collection of the judgment, there still would have been the debt collection moratorium, which during the pendency of that moratorium would have prevented actually collecting the debt from a tenant. And then Also, with respect to the complaint itself, Mr. Gallo, with each successive complaint that he filed, did a fairly good job of responding to the district court's concerns. And so if you were to send this case back with some instruction, I think he would actually benefit from that in better stating a claim on remand. And so unless the court has further questions, I would ask you to reverse.
Thank you. Mr. Gallo, I believe you were out of time, but we'll give you 1 minute for rebuttal.
Thank you. So as to the allegation that there is no contract, the existence of a contract is a federal question under the Contracts Clause. So even though it doesn't technically exist under state law as to one of the 9 alleged contracts, that's not inhibiting this complaint from moving forward, to my knowledge. As to instructions, when I wrote the complaint, I phrased it both as a facial challenge generally and an as-applied challenge to one unit. So if there are instructions relevant to one unit, great, but I think the facial challenge is presented in a way which shouldn't require detailed instructions. This law was imposed on everyone. It was universally applicable. It's not hard to understand how it worked in practice. So I think the facial challenge is appropriate. Another point would be the complaint alleges that all leases were impaired. There shouldn't be this focus on one. Contracts Clause claims, I believe, are inherently facial. The statute is imposed retrospectively. I've got plenty of leases in my name. They were all impaired. My position is there doesn't need to be a payment default for the impairment to occur. The contract just needs to be rendered unenforceable by law. The next point I'd like to reiterate is we hear a lot about existing tenants and invitations, but factually the invitation ends when the lease is defaulted. They do not remain existing tenants under state law. And the complaint alleges trespass by the government. So that's what I assert the physical taking is. I don't know how deep we need to go into some parallel as applied physical taking theory here. The fourth point as to compensation would be the NIC precedent requires compensation at the time of the taking. So I think a complaint which alleges or even admits that some compensation came a year late states the claim from a facial perspective. As to the point that I would be eviscerating a bunch of tenant laws here, that is not true. Not a single law would have to fall. This whole case is about simply whether the government must ensure compensation in the case of breaches of lease. So rent control stays. The government, under my own theory, can do an eviction moratorium whenever it wants. They just have to satisfy the public use clause and ensure compensation. The other point would be, as to Block versus Hirsch, I raised this, I think, in the opening of my brief. I said that the Supreme Court held that to be a compensated taking, and they called it eminent domain in the case of Hawaii. So I would submit that it's already established by the Supreme Court that Block v. Hirsch was a taking. It was a compensated taking. And there's a very big distinction between no taking and compensated taking. And as to the ejectment statute, again.
Should be your last point.
Yes, my final point is the denial of the ejectment claim by Judge Epstein, which we seem to pretend doesn't exist. I contend that is state action. He's not an individual. He's a judge in state court. His act, whether it could have theoretically been overturned, still constitutes a state act. So thank you very much.
Mr. Seidlich, you were appointed by the court to assist the appellant as amicus in this case, and the court thanks you for your assistance.
My pleasure.
We'll take the matter under advisement.
This honorable court now stands adjourned until Monday, March 24th at 9:30 a.m.